Here's a tough question for you. When an employee does something truly awful while on the job, who's really responsible? Is it just that one person? Or does the company that hired them, that put them in that position, also have to answer for it? Well, we're about to dive into a landmark case that completely changed how the law thinks about that very question.
Just really think about that for a second. An employee, someone who's supposed to be doing a job, commits a terrible, intentional crime on company time. Is the employer on the hook for that? This isn't just some abstract legal puzzle. It's a gut-wrenching question that the courts were forced to confront head-on.
Okay, so let's get right into the specific, real-world story where this all played out, a case known as Lister versus Hesley Hall.
So to understand what happened, you need to know who was involved. The case centers on a residential school, a place for some of the most vulnerable kids in society. The perpetrator was the man hired to look after them, the warden of a boarding house. And the defendant? That was Hesley Hall, the company that ran the school and employed. And here's the grim reality of the situation. The warden didn't just fail to do his job, he weaponized it. The very trust, the authority, the access that his job gave him, those became the tools he used to carry out horrific, systematic abuse. His job was to provide care, and he twisted that position to cause unimaginable harm.
So you might be thinking, this seems obvious, right? But the reason this case was so incredibly difficult for the courts came down to one thing: a really outdated legal rule that was basically a roadblock to getting justice.
The whole area of law we're talking about here is called vicarious liability. It's just a legal way of saying that sometimes an employer can be held responsible for what their employee does wrong. You know, it makes total sense if a delivery driver is careless and crashes the company van. But intentional, criminal acts, that's where the law really started to struggle. And this was the heart of the problem, a rule called the salmon test. It basically said an employer is only on the hook if the bad act was just a wrongful way of doing the actual job. So think of a bouncer at a club. If he uses way too much force to remove someone, he's still doing his job, maintaining order, just in a wrongful way. That's the kind of connection the courts were looking for.
And this slide right here shows you exactly why that old rule didn't work. The lower courts looked at the warden's job, providing care, and then they looked at his crimes, systematic abuse, and they said, there's no connection. The abuse wasn't a wrongful way of caring for kids, it was the total opposite. They actually called it a frolic of his own, which is a legal term for saying he went so far off track that it had nothing to do with his employment. So they decided it wasn't the employer's problem. You can see how this just created a complete dead end. The victims were left with nothing, and the organization that put that man in that position of absolute trust was legally off the hook. It was an injustice. The law needed a new way forward, desperately.
And this is where everything changes. The case went all the way to the highest court in the UK at the time, the House of Lords. And they didn't just tweak the old rule. They came up with a breakthrough idea, the close connection test.
They basically threw out that rigid old test and replaced it with something based on common sense. They laid out a new way of thinking. First, you look at what the job actually was. What duties was this employee given? Second, and this is the absolute game changer, you have to ask, did the job itself create the risk or the opportunity for this kind of bad act to happen? And finally, is the connection between that job and the crime so close that it's actually fair and just to make the employer responsible?
Lord Stain, one of the judges, just nailed it with this quote. He said, the employer's business, running the school for vulnerable kids, created the risk. The warden's job put him in a position of power with unsupervised access to the children. The court finally said, yes, that connection is close enough. It's fair and it's just to hold the company liable. And with that, the legal brick wall that had been standing for so long just came tumbling down. The court overturned all the earlier decisions. Hesley Hall was found liable for what its warden did. This was a monumental victory for the victims, and it sent shockwaves through the entire legal system.
So that's the story of the case. But why is it so important? Why are we still talking about it all these years later? Well, let's take a look at the incredible legacy this decision left behind.
Honestly, the impact of this case is massive. It blew the doors open on employer responsibility, making it clear that it's not just about accidents, but also about intentional criminal acts. This new, flexible test has since been used in all sorts of cases: workplace harassment, fights, even employee fraud. The big takeaway is a powerful one. If your business creates a risk, you have a profound responsibility to manage that risk.
And that brings us right into our world today. Think about it. An employee posts something awful on social media that damages their company's reputation. Now, posting online probably isn't in their job description, but their role at the company might give them a platform or credibility. Is there a close connection there? This case from nearly 25 years ago is still forcing us to ask these very modern questions about where a company's responsibility truly ends. What do you think?